This is Adam Hubble, owner of Hubble Law PA in Tallahassee, Florida. I just wanted to talk to you today about some of the things that should be included in your last will and testament and some of the requirements to make your will valid in the state of Florida. This is not a comprehensive instruction on how to draw up a will. It's just some of the most important points. So some of the things in the will, you're going to name what's called a personal representative. In Florida, it's called a personal representative. Other states, it's called an executor. This is the person that you trust to deal with your affairs, deal with administering your will after you've passed away. If you don't name a personal representative, the probate court will name one, and it might not be the ideal person. So you have a chance in your will to name your personal representative, and it can be somebody you trust and somebody that will administer your will in the manner that you would like them to. So that's the first thing. Also, as you well know, bequests or gifts. Bequest is just the word for gifts that you leave in your will. It can be real property, real estate, or personal property. Anything that you own that you have title to. You can leave it to, for example, you might leave it to one person. If they survive you, it means if they outlive you. Otherwise, if they don't outlive you, you can leave it to another person, and you can have several backups. So that's the most obvious thing that you can put in a will are gifts or bequests. If you leave anything out, if you don't specifically leave some of your property to somebody, you want to have a residual clause. So anything that's left over after you've gifted everything, or everything that you've thought of in your will, you should have a clause in your will that says everything else should go to this person or this charity or wherever you want it to go. So that's the third thing, is a residuary clause. You can also, this doesn't apply to all of us, hopefully not very many of us, but in your will you can exclude beneficiaries. If there's someone, for whatever reason, you don't want to get anything, you can exclude them. That can be in your will. And in some place, if you have minor children, you want to name a guardian for your minor child or children, that can be in the will. It can be in a separate writing, or it can be in the will. But that's important, is to name guardians for any minor children. And one last thing that is often included in a will is a reference to a separate writing, to a memorandum. And in that separate memorandum, you can list items of usually personal property, and who you'd like to gift that to. For example, if you have lots of jewelry, antiques of any sort, you might not be able to list all that in your will at the time you make your will, because you might continue buying or selling things, or decide who you want to give something to. So if you reference that other document in your will, then after you're done with your will, you can continue working on that document and change it through the rest of your life, and it'll be valid. Those gifts will go where you want them to. There's some considerations with that. You want to make sure and sign it, and if you have previous copies, you want to destroy those so there's no confusion. But so those are the most important things to have in a will. Name your personal representative. State where you want everything to go. That's your gifts or bequests. State where you want the residual assets to go. That's anything that's left over that you didn't contemplate or name in the will. You can exclude beneficiaries if you want to leave someone out of your will. You can name guardians for minor children, and you can reference a separate writing for all your tangible personal property, all the things in your house. There's some special requirements for Florida wills. This is important because Florida is more strict than many other states about how a will's made and just the formalities of it. So I want to go through a few of those things. First, the very basic one is the person making the will, that's the testator, has to have testamentary capacity. And that just means you have to be of sound mind, 18 years of age. If you're under 18, you can't make a will unless you're an emancipated minor. But if you're 18 and you're of sound mind, that's important. for the will to be valid. The signature has to be at the end of the will. So that's just a requirement in Florida. It has to be signed at the end of the will. It has to be signed by the testator, by the person making the will, and by 2 witnesses. And they all have to be together. They have to be in the presence of each other, and the witnesses have to observe the testator signing. That's very important. If that doesn't happen, your will not be valid and will have no effect. In Florida, what are called holographic wills are not valid. A holographic will would be a handwritten will that doesn't have the proper witnesses. So if you are alone and just write a will out and sign it, if you're in Florida and do that, it's not valid. It's as if you did nothing. Also, oral wills are not valid in Florida at all. They're called non-cupative wills. So oral wills are not valid at all. Another important point, this really is something that should be included in the will, is a self-proving affidavit. This is not a requirement. You don't have to have a self-proving affidavit for your will to be valid. But if you do this affidavit, it makes it a lot easier for your will to be admitted and accepted by the probate court. So you really should do a self-proving affidavit anytime you do a will, if it's at all possible. And the self-proving affidavit is just a small form that's signed by the witnesses and by a notary, so it has to be notarized. But when you have that self-proving affidavit, your personal representative can take your will to the probate court, and if everything's in order, it'll be admitted easily. If you don't have the self-proving affidavit, the court might have to call your witnesses, and it could be a long process. So those are some of the important requirements for Florida wills. Some other just miscellaneous points. After you have a will, make sure you have a safe place for it. Some law offices like to keep every will locked up in their office in a safe place. Some lawyers absolutely don't want to keep them. It's between you and whoever makes your will. Just keep it in a safe place, whether it's in your house or in a lockbox at the bank. If you keep it in a lockbox at the bank, make sure somebody besides you can get to it. When you pass away, if you're the only one that knows how to get into that lockbox, it's going to be a delay getting your will. And obviously make sure somebody actually knows it's there. Out-of-state wills, they're accepted in Florida if you follow the law of the other state. So if you have a handwritten will from another state and that's allowed in that state, and then you move to Florida, Florida will accept your will. So any out-of-state will that was made properly by that state law, it will be recognized in Florida. If you've moved to Florida and you have a will from another state, you might want to update it, but what you have will be valid in Florida. And that's it for now. If you have more questions, leave them in the comments or contact me otherwise, and I'll be happy to answer you personally or make another video addressing that. So thanks for joining. I'll see you next time.